Okay, ladies and gentlemen, I think we can start. Thank you very much for coming back from your lunch break, which was a quick one. I'm really pleased to be here today. Differently from Costas, it's my first time here, and I really appreciate the invitation to see some old friends again, and to be able to share with you my views on the elephant. I would like to start by saying that indeed these are my views, although I'm chairing the Supervisory Convergence Standing Committee. What I will be saying today just expresses my views on this. Although it's my first time and I'm very happy to be here, as I said, I note that you give me a very difficult task. So maybe next year you'll give me an easier one. And why is this a difficult one? Well, I'm in the middle of your weekend. Yeah. I'm the last obstacle to the start of your weekend, and so actually I'm starting my speech when according to the program the conference should be over. So then I have to talk about the elephant, and I have to talk about the elephant after much about it was already said. So I will try. So I will try. My initial plan was to address basically two questions. One was, where are we now on supervisory convergence, aka the elephant? And second, where are we heading to? I think that Costas covered much on the second part, so I will be focusing on the first one. So where are we now and how did we arrive here? And I will start by saying that the storyline of supervisory convergence in European capital markets is a very old one. I dare to say that it's so old that it could have been written by the likes of Plutarch, to have here a Greek reference that will please certainly Costas. So Plutarch, in his best-known work, Parallel Lives, he wrote about several famous Greeks and Romans, and one of these famous Greeks he wrote about was Solon. Solon was an Athenian statesman, lawmaker and poet, who is often credited with having laid the foundations for the Athenian democracy. And in one famous passage of the life of Solon, Plutarch wrote the following. And when Solon was asked whether he made the best laws he could do for the Athenians, his answer was, well, yes, the best they were able to receive. And I'm quoting this because Solon's logic translates to our theme, supervisory convergence, the following way. The highest level of supervisory convergence that European financial supervisors can aspire is mainly determined by the highest level of supervisory convergence that they are willing to accommodate. And, well, in a simpler way, this means that today the questions continue to be how much supervisory convergence do we want and how bad do we want it, okay? Because the starting point is far from brilliant. I think I didn't hear your previous exposition, Giuseppe, but I'm sure that it was a bit critical on supervisory convergence. That doesn't surprise me at all, because when you listen to European senior supervisors themselves, sometimes you hear very harsh statements according to which there is no supervisory convergence in Europe right now. More objectively, when you look at the results of peer reviews, it's not rare to find references to low levels of convergence. So how did we arrive to this point? According to my view, there are many reasons. Some of them were mentioned by Costas, but I would highlight mainly two. First, weak rules. Okay? In the capital markets area, and Costa has also mentioned to it several times, we often say that the single rule book is practically concluded. You hear this all the time. And one would expect this to mean that we have a serious high level of harmonization in Europe right now. And in theory, that is correct. The question is that, however, in practice, the reality is quite different. And we all know that, okay? I want to share a story to you. The first time I came to Brussels was in 2002. I came for a council meeting. I think it was regarding the Transparency Directive. I'm not sure about that, but I think it was Transparency Directive. It was my first meeting, and I was younger, and I was trying to cause a good first impression. And so I prepared well, and during the meeting, I raised several issues regarding the lack of clarity of some rules. The chairman of the meeting, a gentleman whose name I perfectly remember, but I will refrain from sharing with you, listened to me for a while, but then he said, okay, that's enough. And he ended the discussion by politely saying, with a touch of irony, well, thank you very much for raising those points, but let's not forget that Europe is based on the principle of constructive ambiguity. Exactly. And yes, I think he was French. And I just use this example to demonstrate that in practice, in many instances, we are only able to agree on harmonized rules because they are drafted in a way that they allow different meanings for different readers. And so everybody is happy in the end, and we have harmonized rules. But of course, we know that based on different readings of the same rules, naturally, different supervisory approaches will develop. And this is no surprise. So the lack of supervisory convergence that we have in Europe right now is, to some extent, the price to pay for having ambiguous rules or ambiguous principles in the European single rule book. The second main reason for the current status quo is what I called an idiosyncratic willingness to converge. And what do I mean with this? Well, I mean the following. In all fairness, the rules alone cannot take all the blame for this. Many times, the harmonized rule is quite clear, not ambiguous. There is no issue with the national implementation. Okay? We seem to be there. But then, in the end, supervisors, the NCAs, the famous NCAs, still manage to develop different supervisory approaches, simply because that's what they do. And why do they do this? Well, there's a path dependence element here, for sure. Because when a supervisor needs to develop a certain new supervisory approach, the easiest and fastest solution is always to look at the supervisory practices that are already in place. And to derive a new process from the existing ones, without necessarily looking at what else is being done by your peers in Europe, or without any sort of ex-ante coordination. And in addition to this, there's what I call the regulatory arbitrage element. And by this, I refer to legitimate efforts made by the different jurisdictions or the different regulators that in the context of a fragmented capital markets, because we still need to bear in mind that we have a fragmented capital markets in Europe, they try to find within the limits of level 1 and level 2 rules, I mean without incurring in the breach of union law problems that Costas referred to, in the most competitive or interpretation, in the most competitive interpretation or supervisory approach, of course, in order to offer a competitive advantage to participants in their national markets. So for these reasons, and certainly for others too, we end up with different supervisory approaches on the table. When we try to deal with this, it's when we face what I call the idiosyncratic willingness to converge. What is this? Is the following. It tries to translate the following idea. Everybody agrees. So you have different approaches, but still everybody agrees to convergence as long as it's the others converging to my approach. If that is done, fine. There is certainly less willingness to adopt the other's approach instead of mine. So this led us to a situation that is clearly far from perfect, and it became with time more and more visible. The visibility of the shortcomings of this were first of all made by the launch of centralized supervision in the context of the banking union, because there you could really see the contrast. You had the SSM being set up, you had given direct supervision on the most relevant banks, and this was done in a centralized way. And so that could, you have that, and in comparison to this idea of having a decentralized system based on the supervisory convergence that is working like we are discussing. And then there was Brexit. So Brexit also made this more visible because, as Costas also mentioned, London, they were the biggest center for capital markets in Europe, and that means that London worked as a platform for harmonization. You know, it was an implicit harmonization that simply disappeared and made supervisory convergence, the need for supervisory convergence, even more visible, and supervisory convergence itself more necessary. I mean, it's quite clear that on top of the competition that we will face by having our English colleagues sitting on the other side of the table, it's also clear that internally, to address the post-Brexit arbitrage risk, we will really need an unprecedented level of cross-border convergence between the NCAs and the ESAs. So the supervisory convergence clearly became even more the focus for securities supervisors. And the diagnosis, I have to say, was quickly done. I mean, everything is studied, and we all know what are the weaknesses. And we identified the main weaknesses as the following. It was identified that there was clearly a need to increase the effectiveness of supervisory convergence tools. And I give you a few examples, not to bore you too much, but for example, we need to, even in the use of the convergence tools, by this I mean guidelines, the Q&As, opinions, we need to be very mindful in the choices we make in using the different convergence tools. We need to choose the right one for the right purpose. We should, in using them, avoid ambiguity, because sometimes you have Q&As that, I mean, you go through them and you are even more puzzled in the end than you were in the beginning. So that's also not good. Then we know that there is an issue with the dissemination of the convergence tools. We know that they are not necessarily used by all NCAs the same way. There is no disclosure, no transparency on them on the NCA's websites. There are different levels of contact with market participants. There is different practices in terms of translating the convergence tools into the national languages, and so on. And then there is a more fundamental issue of having, different levels of compliance with the agreed positions. I mean, we have convergence tools that are put in place, but then we simply have NCAs that, okay, thank you very much, but I don't comply with it. And this is an issue that should be tackled during negotiations. I mean, sometimes we say that, no, we cannot comply with it because there are problems with the implementation of the EU law into the national jurisdictions. Okay, there are different cases, but they should be identified mostly during the negotiations phase. Because for me, personally, I think transparency regarding non-compliance is a first step, certainly, but should not be the last one. NCAs should make an effort to comply with the agreed positions. Another thing that was identified as being a quick win was to extend the peer review exercises to all level 3 tools. So to guidelines, Q&As, and opinions. Something very obvious like the mapping the use of Q&As and opinions was not done in the peer reviews, and it would be a quick win. If the peer review team, the assessment group goes there, they could quickly see if all the level 3 tools were being implemented by the NCAs or not. It really sounds like a Columbus egg, but somehow it was not done for many, many years. The second area where, okay, we need to tackle this issue, this weakness, was there was perceived there was this reality of having not enough exchanges on real supervisory cases. What Costas mentioned before, it's quite indicative of the state of play. He was saying that when he was chairing a standing committee, 95% of the time, he said, was dedicated to policy work. And so that means that 5% or less was dedicated to supervisory action. So this is wrong. I mean, this is fundamentally wrong. And this is quite obvious. You just need to have more exchanges on real supervisory cases. And we have a few examples at ESMA of these working well. We have the EECS, which works on the enforcement of financial information, where you discuss cases interpretation of accounting standards. And you have the Supervisory Coordination Network that was set up in the context of Brexit, that also worked focused on the authorization process on companies that were relocating from from England, from Britain to the EU. And these are good examples that real supervisory cases work, can be done, and can provide good results. And then also a point mentioned before, there is not enough work made by NCAs and by ESAs on the data that we have now, okay? So we know that now NCAs and to some extent ESAs, they will have the same data, okay? But are they using them the same way? No. And this is a problem because the use of data is a real convergence goal. And data reporting is really important, but it's just the way to get there, you know? ESAs and the NCAs together should develop a catalog of risk indicators and of methodologies that could be applied in the daily supervisory practices by the NCAs. And this, of course, would lead to different results because the markets are fragmented, but the data sets would be the same, the risk indicators would be the same, the methodologies would be the same. So this would certainly lead to address different needs, but there would be convergence in the process and in the base of all. So this is also something that was long ago identified as a weakness to be tackled. And supervisory convergence was an increasing priority, as mentioned. It's included as a priority in the strategic orientation of ESMA since 2016. Still, we could not progress as fast as desired. And the reasons are, you know, what we've been discussing. We don't have a horizontal involvement of all the standing committees in the work of supervisory convergence. They are not working on supervisory approaches. And there is an excessive focus on policy work. Okay, mostly because we still needed to complete the single rule book, but still the balance was not the right one since inception. That is clear to me. And so the European legislator decided to act, again, on the ESA review of 2019. And, okay, so Costa already mentioned where we are heading to. I just would like to highlight, again, a few topics that will be the main changes on supervisory convergence that will be brought by the new regulation. I will focus especially on the ESMA regulation, of course. So on peer reviews, for example, the regulation introduces some changes on the process on the methodology. You will have now ad hoc peer review committees replacing the assessment groups that will be chaired by ESMA staff. Okay? So on top of this, you will have also a more prominent role by the management board of ESMA that we will have to prepare a 2-year peer review work plan, and that will be responsible to ensure consistency across the peer review exercises. And this is very important, this consistency, for example, because you need to, in a peer review exercise, you need to be clear since the beginning on what is the benchmark against which the supervisory practices of the NCAs will be assessed. Okay? And on setting this benchmark, you need to have consistency across the different peer reviews. Otherwise, you would have areas of the capital markets where you would be a bit more demanding and a bit loose in others, and this is also not good. Also, something new is that it's regarding, I'm sorry, just to mention on in terms of the governance of the peer reviews, that you will have, so the enhanced role of the management board, although the Board of Supervisors still approves, of course, the final reports on the peer review, but it will do so by written procedure. Unless 3 members of the BOS object, then you need to have it discussed in a plenary meeting. There will be more transparency on the results of the peer reviews, so the main findings will have to be published. And if there is some information that is taken out from the report regarding the information that is published when compared to the information that was submitted to the management board and to the BOS, these will have to be reported specifically to the EU institutions, to the Council, to the Commission, and to the European Parliament. So to give a better view to the institutions on the levels of convergence that we have in respect of a specific topic. Also, there will be more structure in the follow-ups to peer reviews, because now the follow-ups to peer reviews will become mandatory, and so far they were not. Another area that will be significantly impacted by the new regulation is Q&As. The new regulation makes now a clear distinction between recommendations that are addressed only to one or a group of NCAs or market participants, and guidelines that are addressed to everybody. The also new amendment clarifies that ESMA, when ESMA does not want to conduct public consultations on these documents, it needs to provide reasons for it. And finally, I will refer to the fact that there will be, regarding transparency, a web-based tool where there will be a timely publication of all the questions and all the answers. And the questions that are rejected actually will have also to be published for a 2-month period. Sometimes we need to be careful, just to give you an example on the struggles that sometimes we have good intentions, but we end up with something that is even worse than what we had before. And on the Q&As, actually, this may be a good example. because one of the, remember that I said, one of the weaknesses that we identified is that we should clearly choose the right convergence tools to address the problems. And sometimes the issues are so fundamental that they are not level 3 issues. And there is this understanding that, I mean, this is everything is interpretation, we know, but sometimes it's really an issue that can be solved by a Q&A on level 3. It should be solved by the Commission, you know, at level 1. They should change the level 1 text. And if we or there should be a bigger involvement of the European Commission in the legal interpretation of EU law. Yeah, and that was included in the text of the regulation, which now means that everything that will have to be referred to the Commission will require a decision by the College of Commissioners. How long does it usually take to have a decision by the College of Commissioners? A lot, months. Oh. And so the Q&As that were, you know, typically the flexible convergence tool, in all these cases that will be referred to the European Commission, simply will stop, you know, being useful at all. So instead of having better Q&As, you will have probably less Q&As, because everybody will have a strong incentive to avoid referring these topics to the European Commission. Costa has already referred the enhancements to the breach of union law and mediation powers, so I will not refer to that. I just, regarding the union strategic supervisory priorities, I just would like to highlight that these will be on top of the national supervisory priorities that NCAs will set up. So they will not replace the national priorities, they will come on top, but the NCAs will have to take these into account when they establish their work programs. And as a result, you could have then some possible follow-ups, some guidelines or some recommendations to NCAs, or even some peer reviews to check how these union priorities have been implemented. So I would really conclude here by saying that at this point in time, this is the last train to supervisory convergence. I think that it's clear that we need to be able to show to the world that supervisory convergence in a decentralized model can be a valid alternative to centralized supervision. Because if this last opportunity is not used, then I do agree that the next step will be a big central authority that by definition will be able to impose supervisory convergence in Europe. Thank you very much for your attention.